Judgment in the appeal in the matter of JR55.
Lord Sumption will give the judgment of the court.
This is an appeal from Northern Ireland. It concerns the powers of the Northern Ireland Commissioner for Complaints, one of two statutory ombudsmen established in Northern Ireland in 1969. The Northern Ireland Commissioner for Complaints is a statutory officer charged with investigating and reporting on complaints by members of the public about public services. The present appeal arises out of one such complaint. It was brought against a general practitioner in the National Health Service by the widow of one of his patients who had died of a heart attack. He had visited the surgery on a number of occasions in the months before his death, with concerns about his heart, which, she said, had not been taken sufficiently seriously. The Commissioner investigated the complaint and upheld it. The GP was guilty, in his view, of maladministration of his practice and had failed to provide a reasonable level of care. He did not, however, suggest that these failings had caused the patient's death. He recommended that the GP should make certain changes to the way that his practice was run and should make a payment of £10,000 to the patient's widow. The GP made the changes to the practices of his practice, but refused to pay the £10,000, saying that the Commissioner had no power to make such a recommendation. The Commissioner responded that in that case he would make a special report to the Northern Ireland Assembly, naming and shaming the GP. The GP responded that he had no power to do that either. The Northern Ireland Court of Appeal, by a majority, agreed with the GP on both points. The Supreme Court unanimously agrees that the Commissioner did not have the power which he claims. There are two reasons why the Commissioner was not entitled to make a recommendation of a payment of £10,000. The first is that the statutory instrument from which the Commissioner gets his powers provides that he may not investigate a complaint if the complainant could reasonably be expected to bring her complaint before a court of law. If the complaint in this case was justified, the widow had a perfectly good claim in a court of law. The only reason why the Commissioner thought that she could not reasonably be expected to go to law was that she told him that she was not interested in the money, but only wanted to know what had gone wrong. Having undertaken the investigation on the footing that the widow was not seeking financial compensation, it was not, in this court's view, open to the Commissioner then to recommend a payment of £10,000. If the widow wanted £10,000, she should have gone to court, and if she did not want £10,000, the Commissioner should not have awarded it. The second reason is that the statutory instrument distinguishes between complaints against public bodies and complaints against people like this general practitioner, who are providing a public service under contract with the National Health Service, but are not themselves public bodies. Complaints against people in the position of this GP are dealt with under a different article of the statutory instrument, which is in more limited terms. In particular, the Commissioner is given express powers to award damages against public bodies, but the only power that he has in the case of private service providers such as GPs is to send a copy of his report to the relevant NHS authority. A public body may have a public law duty to comply with an award of the Commissioner, but a private individual has no such duty. It is one thing for a public official to make a recommendation that a public authority should make a payment to a member of the public. It is quite another thing to make a recommendation of that kind against a private service provider who can reasonably expect to be told to pay money only if there is some legal claim against him. The reason why the Commissioner has no power to make a special report to the Assembly on the GP's refusal to pay the £10,000 is essentially the same. The Commissioner's powers of enforcement against private service providers are extremely limited and do not extend to the making of such a report. Accordingly, the Supreme Court dismisses the Commissioner's appeal. It also observes that in those cases where the Commissioner does have power to recommend a monetary payment, it is incumbent upon him to explain what that payment represents and how it has been arrived at. Given the absence in this case of any finding that the GP's professional failings caused or contributed to the death of his patient, and the absence of any explanation from the Commissioner of how he got to the rather high figure of £10,000, it is hard to discern any rational basis for this particular recommendation.